Hey guys. So I thought we could have a look at the motion to suppress evidence obtained due to illegal searches and seizures. This is to do with it says illegal and unlawful conduct of the state, where, first of all, when Lizzie Bigham went to get her search warrants, she failed to provide sufficient probable cause. She did get the subscriber and transactional information, real-time range-to-tower round-trip time data at the time of phone activity, and ongoing global positioning system locations, so CSLI, and it was from 7th of May until 13th of May 2024 at a rate of every 15 minutes. And Cruz has put here that the affidavit lacked facts asserting that evidence of the crimes of and that would be found in Mr. Faust's phone records, or that said information was needed to apprehend him. So they're asking for the DNA evidence obtained and all evidence derived therefrom to be suppressed as fruits of a poisonous tree. So it says that probable cause for a search warrant, you have to show that, number one, a crime was committed, number two, that the items sought are connected with the crime, and that the items sought will be found in the place to be searched. So it is not merely doubtful as to whether Elizabeth Bigham's May 7, 2024 search warrant affidavit provided sufficient probable cause to support the issuance of the resulting search warrant. Rather, the affidavit is wholly devoid of probable cause. So, yes, they did need the search warrant to obtain the data. And it says that the Supreme Court says that an individual maintains a legitimate expectation of privacy in the record of his physical movements as captured through CSLI. Okay, then so Elizabeth Bigham's search warrant affidavit failed to set forth facts alleging that Mr. Faust committed any crime. So instead, the affidavit said, the official autopsy report documented this. I'm not going to read that. Evidence for an SA kit was collected, including the collection of all of these. CODIS provided a possible investigative lead that a partial major DNA profile from the oral swabs matched a reference sample from Mr. Faust. The state's lack of evidence regarding a connection between Ms. Baker and Mr. Faust, and that he was intentionally evading law enforcement by his erratic driving and counter-surveillance methods. So it goes on to say that to justify this type of warrant, Bigham was required to provide sufficient facts to the judge that contraband or evidence of a crime would be found within the CSLI information. So then he gives the example of a CSLI information providing the identities of the shooter and accomplices, evidence of their location, and communications around the time of the crimes. But Lizzie requested the warrant for the sole purpose of tracking Mr. Faust with the information, not for the apprehension of Mr. Faust or because the CSLI information itself contained or was evidence of a crime. So it says needs to have a link between the property and any criminal activity. And then, so she also said that he was performing counter-surveillance and driving erratically, which inhibited the state's ability to conduct surveillance. And when they looked at her case file notes, so this is what she wrote in the search warrant, that on Friday, 3rd of May, police began traditional covert surveillance of Faust. However, traditional surveillance has been unsuccessful, blah-de-blah. And then it goes on to say that her case file says that, in fact, surveillance didn't start until 5th of May at 12 a.m. and they simply failed to locate him. So if you take that statement out, this statement here, then look at the affidavit again, then based on the information presented, there isn't any sufficient information to authorise the issuance of the search warrant. And then they used the location information to conduct a traffic stop to obtain the DNA sample. And that resulted in the issuance of multiple arrest warrants. And so they're wanting all of that to be suppressed under the fruit of the poisonous tree doctrine. Then this is about the search warrant being overly broad and just saying that people have a right to not have people just rummaging through their stuff, pretty much. So the search warrant affidavit lacked any specific assertions in the affidavit that demonstrated that Mr. Faust's movements on the dates were somehow connected to the homicide, or that the CSLI would somehow assist in the apprehension and arrest of Mr. Faust. So when the government tracks the location of a cell phone, it achieves near-perfect surveillance, as if it had attached an ankle monitor to the phone's user. This is again going through the warrant being overbroad. And then when they did do the traffic stop, they got his DNA without his consent because they told him that they wanted to do a breath test for alcohol. So he consented to that, but that doesn't mean that he then consented to his DNA being taken. So that's what this part's talking about. So on the 8th of May, Georgia State Patrol Trooper N. Wooten was contacted by Investigator Frost with the FBI Safe Streets Task Force in Athens regarding assistance with conducting a traffic stop. using the CSLI information and attempting to obtain a DNA sample during the traffic stop. So he waited for Mr. Faust's vehicle to drive past and then basically followed him, pulled him over, told him that it was because, where is it? Trooper Wooten advised that the traffic stop was based upon Mr. Faust's brake light not functioning, dark window tints, and post-traffic stop that there was a crack in the windshield. And he said he was going to just get a warning ticket. And so got his driver's license, auto insurance, and then asked him to step out of the vehicle. And then when he did get out of the vehicle, Trooper Wooten stated to Faust, "I smell a little weed, a sweet smell. Have you had any alcohol today?" And Mr. Faust said, "I don't drink, I don't do no drugs, no alcohol, no nothing. I'll do any test." And then the trooper said, "Will you blow into this tube real quick for me?" And he responded, "Yep, I will do that. I don't do no drinking." And the trooper said, "I believe you." Mr. Faust also told the trooper that he doesn't consume any drugs or alcohol multiple times. And so, yeah, the purpose was to provide a breath sample to determine whether or not he was drinking alcohol. But he didn't consent to blow into the alcohol sensor for the purpose of providing a saliva sample for DNA testing. So they're saying that the DNA evidence resulting from that should be suppressed. And then, as I understand it, the rest, so this one here is just about diverting from the purpose of the traffic stop. And he didn't end up doing a license check. He didn't start writing the warning citation or anything. He just diverted from the purpose of the stop to conduct the test. And then the F is obtaining Mr. Faust's saliva for DNA testing from the preliminary breath test tube constituted an illegal seizure, as said seizure was conducted without a search warrant. So the DNA evidence and all evidence derived therefrom must be suppressed. So on May 8, 2024, Georgia State Patrol Trooper N. Wooten, employing a subterfuge DUI investigation, asked Mr. Faust to provide a breath sample for the purpose of determining whether he was drinking alcohol. To provide said breath sample, Mr. Faust was required to cooperate and blow deeply from his lungs into an alcohol sensor breath test machine through a straw, which was the pretextual method used to obtain saliva for the purposes of a DNA sample. And then his DNA was taken from the saliva that was in the straw to obtain the profile. So obtaining the saliva for DNA testing constituted an illegal search, as said search was conducted without a search warrant or exigent circumstances. So it should be suppressed. So they're saying that, yeah, that should be suppressed, and then his statements should be suppressed as well. Then it talks about the trooper's use of deception to obtain the saliva for DNA testing, and that it's violating Mr. Faust's right against self-incrimination, and thus all evidence obtained in violation of said right must be suppressed. So you can't just get someone to do a breath test so you can get their DNA without telling them. So in summary, Elizabeth Bigham misrepresented information in the search warrant affidavit. So the resulting search warrant was not supported by probable cause. Therefore, all evidence should be suppressed as a result of law enforcement possessing Mr. Faust's CSLI information, including the DNA obtained during the traffic stop and the resulting arrest warrants and his statements. And that the search warrant was overly broad, not supported by probable cause, and the DNA, which was obtained unlawfully, use of deception to coerce him, and you look at the difference between how he was treated and how Chris Melton was treated. And I would have thought the innocent until proven guilty kind of comes into play here. But to say that there's not any underlying racial undertones would be, I think, a little bit silly, in my opinion. So why did it have to all be so sneaky? I don't understand. If they had such good evidence and they were so sure, why did they have to get a search warrant to follow him? Why did they have to get his DNA without telling him? Just doesn't add up. Anyway, that's all. Bye.